At that time, when we became a republic, 370 was there. And 370 mentioned the Constituent Assembly. But the Constituent Assembly had not yet been convened in the state of Jammu and Kashmir. That was convened in 1951, December. Point is that there was this understanding between the government of India and the state that we will have a Constituent Assembly which will determine the future course of action. Determine whether or not, in fact, 370 should be abrogated at all or not. That decision was with the Constituent Assembly, which is why it is called a temporary provision. So, the point that I'm making here is very simple, that the government of the day accepted the fact that our relationships with the Jammu and Kashmir government are on a separate footing. The provisions of the Constitution, unless made applicable through a presidential order and agreed to by the government, shall not apply. The residuary power will vest in the state. It is the state which must pass laws. The government of India can't, under the issue of repugnancy, doesn't apply. So, this status is accepted. That's how 370 came into being. And it continued. So the assumption is that if the president passes a notification for the application of any law to the state of Jammu and Kashmir, he has to seek concurrence. He cannot do it without concurrence. Consultation. Yeah. So it was a collaborative relationship in a sense. There was a constant dialogue going on. This is what we wish to do, and consult the state agrees, which is why most of the laws were made applicable. There was hardly any law that was left. So in a sense, they were incorporated separately in the Constitution of India in its application to the state of Jammu and Kashmir orders.
What happened to currency, for instance?
Currency, was the Sarveri Riyasat, as your lordship knows.
Currency.
No, currency was Indian currency.
No, because, if you see currency in the Constitution is governed by entry 36 of List 1.
Yes.
But there's no reference to entry 36 of List 1 in the adaptation order.
Well, it will come later. There were adaptation orders, subsequent adaptation orders. I'll come to that. I'll show that, your lordship. Because several, this comes in 1954, we have another adaptation order. There are several, give me on the list of several adaptations. We got a list by your lordship.
So were the subjects broadened by the subsequent adaptation order?
Of course. They were broadened, Every state they were broadened. We have an order of 52, we have an order of 54, we have an order of 71, an order of 74. Because the powers were extended, and the state, after consultation it was done. The state was ad idem with the union, the state itself in its constitution says that we are integrated into India. There was no question. The Constitution of Jammu and Kashmir itself says that we are an integral part of India. So where's the question? The only thing is that there's a unique structural system in place, a constitutional structure which was in place, which suddenly, on the 6th of August, was done away with. And with the greatest respect, though I don't want to use that expression, suddenly, in Parliament, it was said that we are doing this at 11 o'clock. Nobody knew about it. There was no consultation of any sort. So it was, as I said, the governor of the state and Parliament, and of course the powers that be, they decided to do this one fine morning and tossed it out. So, page 41. The Government of India published its white paper on Indian states clarifying the nature of Article 370. The effect of this provision, this is important. We're talking about 1950 itself. The effect of this provision is that the state of Jammu and Kashmir continues to be a part of India. Nobody disputes it. Nobody ever disputed it. It is a unit of the Indian Union. And the Union Parliament will have jurisdiction to make laws for the state on matters specified either in the instrument of accession or by later additions with the concurrence of the government of the state. My lords asked me that question. Steps will be taken for the purpose of convening a constituent assembly. Lordship knows, Mullahs, this is very important. At that time, when Mullahs, we became a republic, 370 was there. And 370 mentions the Constituent Assembly. But the Constituent Assembly had not yet been convened in the state of Jammu and Kashmir. That was convened in 1951. December. Point is that there was this understanding between the government of India and the state that we will have a Constituent Assembly which will determine the future course of action. Determine whether or not, Mullahs, in fact, 370 should be abrogated at all or not. That decision was with the Constituent Assembly. Which is why it is called a temporary provision. Not for any other reason. It's in that chapter of the Constitution. So this whole argument that this temporary provision was 370 was temporary, no. It was temporary because between 1951...
Mr. Sibal, what is the date of this white paper?
50. I'll give you...
No, you're not given the date.
I'm sorry, it's at page 121. Just see the date. We'll just give it to you in a minute. So on the 1st of May 1951 now, Yuvraj Karan Singh issued a proclamation directing the establishment of an elected Constituent Assembly. March 1950, I'll give the exact date.
Okay.
It is March 1950.